Well, I'm still confused, but what if the bookseller said it's over there on the table with the other trustworthy books?
I mean, I think at that point you would be asking, could it conceivably be an actionable tort to describe the book as trustworthy?
Well, we're putting a lot of weight on organization, but doesn't it really depend on how we're organizing it and on what the basis of the organization? For example, we could say this, you could organize it on the basis of what's more trustworthy than something else.
I think that might matter with respect to whether there was substantive liability under the underlying cause of action. It shouldn't matter for purposes either of the hypothetical immunity statute I described, which focuses exclusively on the contents of the books, or for 230C1. Now, Mr. Schnapper said in a colloquy earlier that he thought the allegations in his complaint are basically the same as those in the Twitter complaint. And the government is arguing in Twitter that those allegations are not sufficient to state a claim under the Anti-Terrorism Act. So our interest in 230C1 is not in allowing this particular suit to go forward. It is in preserving the distinction between protection for the underlying content and protection for the platform's own choices.
Well, I just think it's going to be difficult. How would you respond to Justice Gorsuch's hypothetical about the artificial intelligence creating content organizational decisions?
I mean, I think the organizational decisions could still be subjected to suit, whether you think of them as recommendations or simply as the platform, the operation of the platform. It's still the platform's own choice. And if you ask, how did a particular video wind up in the queue of a particular individual? It could be some sort of artificial intelligence that was making that choice, but it would have to do with the YouTube's administration of its own platform. It wouldn't be a choice made by any third party who had posted, because third parties who post on YouTube don't direct their videos to particular recipients. And I do want to emphasize this theory, this rationale applies even in the most mundane circumstances. For instance, if you do a Google search on the name for a famous person and you misspell the name slightly, you still get lots of content about that person. Google knows that it's smarter than we are, and it knows that more about what we want than the literal terms of our search might suggest. I went to the court's website and used the docket search function and typed in Google and left off the final E, and I got a message that said no items found. In order to call up the docket for this case, you have to spell Google exactly right. Now, the choice between those two modes of operating the platform, it's extraordinarily unlikely, almost inconceivable that it could ever give rise to legal liability. But those are choices made by the platforms themselves. They are not choices made by any third party. They just don't implicate 230C1. And any conceivable lawsuit about the decision to use one mode of operation rather than another presumably would be dismissed on the merits